Like the President of India, the governor is also bestowed with special legislative power of promulgating ordinances when the legislative assembly of a state is not in session, or where both the houses of the legislature are not in session. If he is satisfied that the circumstances exist which will render it necessary for him to do so, but the governor cannot, without instruction from the president, promulgate any such ordinance in the following circumstances. Number, if a bill containing the same provision could under this constitution have required the previous sanction of the president for the introduction thereof into the legislature, or number B, he would have deemed it necessary to reserve a bill containing the same provision for the consideration of the president, or number C, if an act of legislature of the state containing the same provision would under this constitution have been invalid unless have been reserved for the consideration of the president, it had received the assent of the president. Article 213 clause 1. In case of Mr. H.D. and General Mills versus State of Haryana, AIR 1976, and HI, it has been held that in case of amendment to an act of the state which received the assent of the president, it cannot be held to be invalid only because the amending act was neither reserved for the assent of the president nor it received the assent of the president. Effect of ordinance. An ordinance promulgated by the governor should have the same force and effect as an act of the legislature of the state assented by the governor. It can override the judgment of High Court over Article 226. State of Orissa versus Bhupendra Kumar, AR 1962, Supreme Court 945. Duration of ordinance. Every such ordinance shall be laid before the Legislative Assembly of the state, or where there is a Legislative Council in the state, before both the House, and shall cease to operate after expiration of 6 weeks from the reassembly disapproving it is passed by the Legislative Assembly and agreed to by the Legislative Council. If any, upon the passing of the resolution, or as the case may be, on the resolution being agreed to by the council, and may be withdrawn at any time by the governor, where the House of Legislature of a state having a legislative council are summoned to reassemble on different dates, the period of 6 weeks shall be reckoned from the latter of those dates for the purpose of this clause. If so far as an ordinance make any provision which would not be valid if enacted in an act of legislature of the state, it shall be void under Article 213 clause 2 explanation. If an ordinance is repugnant to an act of parliament or an existing law with respect to a matter enumerated in the concurrent list, such ordinance, if it in pursuance of instruction from the president, shall be deemed to be an act of legislature of the state, which has been reserved for consideration of the president and assented by him. Article 213 clause 3. In DC Vadhava versus State of Bihar 1987, 1 SCC 378, the petitioner challenged the practice of the state of Bihar in promulgating and repromulgating ordinances on a large scale by passing their legislature and keeping them alive for a period of time. Supreme Court held that this amounts to fraud upon the constitution and therefore unconstitutional. So that's all about this video, where we discussed about the ordinance making power of governor. If you find it useful, like, subscribe.